Hello all, welcome to Paritranaya. In this video, we shall analyze and understand the articles of The Hindu's editorial which have appeared on June 22, 2023. So in this video, first we shall look into the various articles that have appeared in The Hindu. The Hindu's editorial. So the first one is Overkill. So this is the first article that we will be discussing. After that, we have second article, More Hit Than Miss in India-Nepal Ties. So this will be the second article that we will be discussing. Next, the third one will be Heat and State. So the article, Heat and State. Next, Spare a Thought to Psychiatric Caregivers Too. So this will be the next fourth article that we will be discussing. Next, after that, we shall discuss about Rethink the Retention of Sedition. This article we will be discussing. Then UAPA fiasco in Telangana, the next article. And finally, the last article of the editorial that we will be discussing is the gender gap in clinical trials and disease funding. The gender gap in clinical trials and disease funding. So here we have seen the list of articles that have appeared. So now we shall start discussing these articles one by one and try to understand these articles from exam point of view, both prelims as well as mains. Okay. So first we shall start with the article that is Overkill. Okay. So this article, Overkill, it is related to the situation of Manipur. It is related to Manipur. So first we need to know about the background of Manipur, or the recent events or developments that have taken place in Manipur. So we are aware that recently some unhealthy developments took place in Manipur. So what was that unhealthy development? So there are two communities in Manipur, Metis and Kukis. So a tussle that started between the Metis and Kukis, it almost spread to the entire state. And in order to control this, government what it did, it imposed internet shutdowns. So in order to the violence that was arising, in order to control it, so government of Manipur, it imposed internet shutdowns. Okay, internet shutdowns. But later on, a petition was filed in the Manipur High Court. Someone filed a petition in the Manipur High Court seeking the restoration of internet, because internet is a very important resource and it is we are very much dependent on internet. So a petition was filed for the restoration of internet access in Manipur. But Manipur's government was not in favor of restoring the internet, because still the situation was not under control. So in the court, Manipur government, it argued. What it said, it decided to extend the net shutdown. So whatever the internet shutdown was there, it wanted to extend it. So the Manipur government defended in the High Court, saying that the shutdown were needed. Why it were needed? To block some websites where inflammatory material could be published. So Manipur government's stand was that there are certain websites, if we do not block them, then what happens? So people will start posting inflammatory material, and it may cause the situation much more worse. So that is why it was not interested. But taking all these things into account, what the Manipur High Court did, so Manipur High Court has granted limited internet access. Okay, not completely, but it has granted limited internet access in few areas. Okay, in few places in the state. Next, so let us look what happens when internet is shut down. So shutdowns, whenever internet is shut down, it has a crippling effect on the many economic activity and livelihoods. So now we have become so much dependent on internet. As an UPSC aspirant, if there is no internet, then every day our preparation will become very difficult, because we are so much dependent on the internet. So similarly, for many other activities, we require internet. So the most dominating is e-commerce. So on a day-to-day basis, we are involved in e-commerce, we purchase items and all. And if internet is down, we cannot involve ourselves in these e-commerce activities. Okay, e-commerce activities. So in this way, it will affect the economy as well as livelihood. That is why restoration of internet is very important. That is why a petition was filed. But again, government defended the extension of the internet shutdown, and taking all these things into account, Manipur High Court, it has just restored to a limited extent, and that too in few places. Next part is very important. So the order seeking to extend the shutdown. So whatever the Manipur government, the order which it gave to extend the shutdown. So what were the reasons that the Manipur government quoted? Manipur government quoted that there is a threat to law and order. And also there are some anti-social elements. So because of them, we want to extend the shutdown. But here, what the writer wants to highlight here is, so whenever you are imposing the internet shutdown, so you impose it through which act and which rules? So whenever there is a imposition of internet shutdown, it happens under Telegraph Act 1885 and also the corresponding rules. But the Telegraph Act and the rules, they say that we can impose an internet shutdown whenever there is a public emergency. Or whenever there is a threat to interests of public safety. Whenever there is a threat to the interests of public safety or there is a public emergency, then we can impose internet shutdown under the Telegraph Act 1885 and the corresponding rules. But here the government has not cited the reason of public emergency or public safety, but rather it has cited threat to law and order and the presence of antisocial elements in order to impose the internet shutdown. So these are some of the background things that we need to understand. So from UPSC point of view, what kind of questions might be posed? So generally they'll pose a question like this. When it comes to internet shutdown, who has the power to impose internet shutdown? Whether central government has it or state government also enjoy that power. So we need to think from that direction. And also when the internet shutdown is being imposed, so under which law can we impose restrictions? Can we impose shutdowns? So we need to understand that it is under Telegraph Act. Okay, Telegraph Act, and these are few of the points which are important from Prelims point of view. And even in Prelims they may ask you a question like this. So under Telegraph Act, what are the grounds on which you can impose a shutdown? So whether public emergency is a ground? Yes. Whether public safety is a ground? Yes. Whether law and order is a ground? No. Whether presence of antisocial elements is a ground? No, that is not the ground. So all these things, they are important from Prelims point of view. So if at all you have read the Hindu, you already read the Hindu editorial, then what you do is, we have posted a practice test link in the test below, link of that practice test below. So you can just give that test. So if you are able to answer, then it's well and good. Otherwise you can come back to our video and again go back to those practice questions. So here next we need to understand the Supreme Court in Anuradha Basin versus Union of India. So in a particular case, so what is that case? Anuradha Basin versus Union of India. So this case, when did the judgment come? The judgment came in 2020. The Supreme Court gave a judgment. So in that judgment, what the Supreme Court said? It said that indefinite suspension of internet service was in contravention to the law. It means it said you cannot suspend the internet eternally. Okay, there should be a time frame for which internet should be shut down. So indefinitely it should not be shut down. And if indefinitely you are shutting the internet, then it means you are violating the fundamental right. So which is that fundamental right? So it says that, so fundamental right to carry out commercial work using internet. Okay, but if you look at our constitution, nowhere they have mentioned about this fundamental right explicitly. But through this judgment, we can draw an inference that right to carry out commercial work using the internet is considered as one of the fundamental right under freedom of speech, which comes under article number 19. So these are some of the background things which we should be able to connect it. Now coming to prelims. So what kind of questions can be asked in prelims? So here question in prelims, they may frame in this fashion. So whether right to carry out commercial work using the internet is a fundamental right? Yes, it is a fundamental right. So under which article it is fundamental right? Whether it is a fundamental right under article number 19 or article number 21. So such kind of questions they may pose. So here we need to understand that. So to carry out a commercial work using the internet is a fundamental right under article number 19, that is freedom of speech, and not article number 21. Not 21. Generally, UPSC will not focus on such kind of judgments and all. So Anuradha Basin and versus Union of India. So these kind of questions will not be asked in prelims. But when we are writing mains answers, if at all we are able to quote this judgment while writing our answer, so definitely our answer will become enriched and it will fetch more marks. Okay, so this judgment and this name, it becomes important from mains point of view. Next, in the same judgment, Supreme Court said that suspension, whenever you are suspending the internet, you have to adhere to the principle of proportionality and must not extend beyond necessary duration. So whenever you are doing some things, it should be proportion. Okay, so you should not do more than what is required, and also not extend beyond necessary duration. If you think that in order to bring the law and order under control, you require 10 days of time, then you can shut down for 10 days. But you should not continue it for indefinitely. Okay, you should not indefinitely continue it. So again, very important from mains point of view. So it appears that the government is merely using the shutdown as a substitute for enforcing law and order. So from these developments, what we understand that, so government, it is becoming difficult for the government to enforce law and order. So the best tool that it can use is shutdown of internet. So this should not happen. So shutting down of internet should not be used as a tool for enforcing law and order, because while enforcing law and order, it simultaneously causes a lot of problem to the whole economy and many livelihoods as well. Next, these are some of the points which can be beneficial from mains point of view. So what are the various measures that the Manipur government can take or the civil society can take in order to restore peace in Manipur? So there are a few steps. So restoring the confidence of all the stakeholders. So as violence is going on in Manipur, so there are various stakeholders involved. It may be Metis or it may be Kukis. So all the people of different communities, they have to be taken into confidence. So only that bringing them into confidence itself can help us to bring or restore peace in Manipur. Engaging with civil society actors. So very important. We have to engage with all the civil society actors. Next, we need to isolate the extremists and pursuing a step-by-step approach. So the main cause for this violence is extremists. So these extremist ideas, when they penetrate into the masses, then it may trigger violence. So if the extremists and the extremist ideologies are isolated, and then definitely it can help us to restore peace. Also, community representatives. Now it may be either Metis or it may be Kukis. So representatives have to be called, and we should ask them to rise above their ethnic identities to pursue peace. Okay, so if they are confined within their ethnic identity, then peace cannot be restored. So always they have to rise above their ethnic identities, then itself peace can be restored in Manipur. Okay, so this was about the first article. Okay, first article. Next, the second article, more hit than miss in India-Nepal ties. So again, there are few points here which are important from prelims point of view, and also there are few points which are important from mains point of view. So why this article has appeared? This article has appeared in the context of improving India-Nepal ties. So India-Nepal ties, recently they had been strained, but now again they are becoming good. So here we need to understand the things from various perspectives. So who is the present Nepal's Prime Minister? Pushpa Kamal Dahal Prachanda. He's also called as Prachanda. So these kind of questions UPSC will not ask who is the Prime Minister of Nepal and all. But out of curiosity, we need to know about our neighboring countries and who are the Prime Ministers of our neighboring countries, at least presently. So a very important development, Nepal's transition to a federal republic. So before 2008, what kind of system existed in Nepal? It was monarchy. It means king used to rule Nepal. But from 2008 onwards, it started making a transition towards democracy, a federal system. Okay, similar to the system that exists in India. But such kind of transition, they do not happen overnight. Generally, they take years together. So in 2008, it started. So whenever we want to move towards a republic, federal or democratic system, so we require a constitution. So that's why a new constitution writing exercise it started. And finally, a constitution for Nepal, it was adopted in 2015. So Nepal adopted its constitution in 2015. So after the adoption of constitution, 2 rounds of election have taken place. One in 2017 and another one in 2022. Okay. So when were the election held in 2017 and 22? All these things are not important. So from prelims point of view, what are important? So whether Nepal is still monarchy or federal republic, it's a federal republic. When did Nepal adopt a constitution? In 2015. Next here, few of the things are very important. Next following things which are important from mains point of view. So there was a path-breaking visit to Nepal in August 2014 by Prime Minister Modi ji. So during his speech, Modi ji invoked neighborhood first, neighborhood first policy. So in order to attract all the neighbors, so he invoked neighborhood first policy. So, but later on what happened, and during in his neighborhood first policy, there was a focus on connectivity. Okay, connectivity, and he also focused on three important what developments. One is highways, information ways, and transways. Okay, transways. When the developments were going good, all of a sudden there was a bottleneck. What was that bottleneck? So the relationship between India and Nepal, they spoiled because of the economic blockade. Economic blockade. So what is economic blockade? So India imposed certain kind of restrictions on Nepal. What is that? We stopped supplying few items to Nepal, but Nepal was dependent on us. So this caused a kind of consternation in Nepali people against India. Okay, so ties were weakened in 2015 because of the economic blockade which India imposed. So for time being, we shall not focus what exactly was the reason for economic blockade and all, but this was one of the reason why the relationship between India and Nepal spoiled in 2015. So now that repairing the relationship that has been spoiled, now repairing exercise is going on in what full swing, and now the relationships are improving. Okay, improving. In this context, we need to understand the various cooperation between India and Nepal. So the very important cooperation is hydropower cooperation. Why hydropower cooperation? Because Nepal is endowed with viable potential of close to 50,000 megawatt of hydropower. Okay, so whether that 50,000 megawatt is important, no, we need not memorize it, not important. So what we need to understand here is, in Nepal, we have a tremendous potential for hydropower generation. But whether that potential has been realized, not realized to its fullest extent. So till a decade ago, so 10 years back, Nepal had installed capacity of barely 1,200 megawatt. So just 10 years back, even though it had this so much tremendous potential, it had an installed capacity of only 1,200 megawatts. Okay, megawatts. So that much electricity was not sufficient to Nepal. So that's why it was dependent on the neighboring countries, and especially on electricity imports from India. So just 10 years back, Nepal was import dependent on India's electricity. But because of India's involvement in Nepal and Nepal's hydropower development, so the scenario there has changed. So today it has an installed capacity of 2,200 megawatt. So again, these values are not important. Okay, these values are not important. But what is important is, previously whatever the capacity is there, in just a span of 10 years, it has almost been doubled because of India's involvement. And to such an extent the development has taken place is, in rainy season, Nepal exports power to India. Very important point to note. So just 10 years back, Nepal used to import electricity from India, but now in rainy season or in season, Nepal exports electricity to India. It does not mean that Nepal has become completely self-reliant. In season, it exports power to India, but in lean season, when there is no rainfall, so Nepal does import power from India. It does not mean that it does not import from India. It imports power from India, but the amount of electricity that it used to import 10 years back has now significantly got reduced. So it has dropped from almost 20% of its requirement to 10%. Okay, so 10 years back, whatever the amount of electricity that used to import, now it has significantly got reduced to almost 10%. Okay, 10% in the last 5 years. So all this has happened also because of the significant contribution that India has made with respect to hydropower generation in Nepal by signing many agreements and building many projects in Nepal. Okay, Nepal. So apart from that, both sides have finalized a long-term power trade agreement also. So recently, India and Nepal, they have signed a power trade agreement. So this point is not that much important. So just at a superficial level, we shall understand that power trading agreements have been signed, wherein India has promised to buy so much of power from Nepal. Similarly, Arun 3 project in Nepal is being built by Indian company. Okay, so which company exactly? Not important. From exam point of view, we need to understand that Arun 3 is a project, hydro power project in Nepal, which is being built by India. So in UPSC prelims, generally, in order to confuse us, they may ask a question or pose a question like this. So Arun 3 is a project which is being developed in Afghanistan by India. Okay, it will be false. So it's a project which is being developed in Nepal by India. Similarly, Arun 4 project. Next, National Hydroelectric Power Corporation Limited of India has also initiated few projects in Nepal. Next, apart from that, Pukot Karnali project. So again, it is a initiative of India in Nepal. So all these things we need to know. So now what happens as the number of names they go on increasing, we often get confused. Whether do we need to remember each of these names? Okay, not necessary. Not necessary, because practically it becomes very difficult for us to retain all these names. So at the time of examination, just at the superficial level, we can focus, just go through them once. Similarly, a high voltage transmission line exists between Butwal and Gorakhpur. Okay. Next, apart from this, India has been playing a very important role in sub-regional cooperation. Sub-regional cooperation. So here is an example. Now, here we have Nepal. Here we have Bangladesh. Bangladesh. So Nepal and Bangladesh, they do not have any kind of land connectivity nor sea connectivity. So here in between we have India. In between we have India. So if Nepal wants to export electricity to Bangladesh, then it has to happen through India. But if Nepal wants to establish its own infrastructure through India, then it will be very costly affair. But now what Nepal has requested India to use the Indian grid and transport electricity to Bangladesh. And to this proposal, India has agreed. So it means India is playing a very important role in sub-regional cooperation. So even these points can be quoted in mains. Okay, mains as well. Definitely it will help us to enhance the quality of our answer. Next, apart from this, in order to facilitate the movement of goods and people between India and Nepal, other measures have been taken. So one is Rupaidiya Nepal Gunj integrated checkpost, Sunauli Bairawa integrated checkpost, Dodhara Chandni, one more checkpost we want to establish, and already a memorandum of understanding has been signed. So Jaynagar Purtha Railway, okay, Purtha Railway line, this exists between India and Nepal. So there are plans to extend it further. Okay, extend it further. Extend it further. Okay. Next, when it comes to oil cooperation, so we have seen with respect to electricity and other types of connectivity. Next is oil cooperation. So Motihari Amlekganj petroleum pipeline. So we need to understand that it exists between India and Nepal. That much information would be sufficient. Next, new pipeline between Japa and Siliguri. Okay, a memorandum has been signed. Okay, memorandum has been signed. Next, apart from these developments, there are also certain irritants. Okay, certain bottlenecks in the relationship between India and Nepal. So what are those? So let us understand. So one is Agnipath scheme. So Agnipath scheme. So it's a kind of irritant in the relationship. Why? Because always Nepali people, they have served in Indian army. But because of some provisions present in the Agnipath scheme, so some of the Nepalis were prevented from entering the army. So that's why Nepal got irritated. Okay, Nepal got irritated. So we need to resolve the problems which are being faced because of this new Agnipath scheme. Okay, Agnipath scheme. In this context, we need to know about the history. What is the history? So whether Nepal is being inducted into India's army, whether this is happening for the very first time or historically it did existed. So historically, it started when in Indian Army's Gurkha regiment, Gurkha soldiers from Nepal were recruited. So when did it start? It started in 1816 by the British Indian Army. So even after getting independence in 1947, so that treaty continued, and even today Nepalis are part of Indian Army. Okay. So now as this has become a irritant, so steps are being taken in order to overcome the differences that have arisen between India and Nepal. Similarly, Kalapani boundary issue. So it's a place in Uttarakhand. So it is present in India, but recently because of some political reasons, so Nepal, it altered its map and it said that Kalapani belongs to it. Okay, Kalapani belongs to it, and there was a small tussle between India and Nepal. So this is a very sensitive political issue, and it needs a lasting solution, and it can happen only through political will and understanding. So this is another issue. So from UPSC point of view, they can ask you a question like this. So Kala Pani issue is an issue between India and Pakistan. False. It's an issue between India and Bhutan. False. India and Bangladesh. False. It's an issue between India and Nepal. Okay. So in which part of India is Kala Pani present? So in Uttarakhand region. Uttarakhand region. Next, apart from that, India-Nepal Treaty of Peace and Friendship. So this Treaty of Peace and Friendship was signed in 1950. Somehow in Nepal, people they think that this treaty is unfair to them. But before they jump to such kind of conclusion, they have to understand the reality that existed in 1949. Because the Nepali regime was perturbed by the Maoist revolution in China and subsequent takeover. So all these things, minute details are not important. So just at a superficial level, let us understand that India-Nepal Treaty of Peace and Friendship of 1950. So it is being interpreted in a native manner by few Nepalis. Okay, Nepalis. Even that issue has to be resolved. Okay, even that issue has to be resolved. So here, what we need to remember here is this treaty, how it is beneficial. The treaty enables Nepali nationals equal treatment in terms of employment and permits them to apply for any government job. So because of this friendship treaty, Nepalis can apply to any kind of jobs in India, both private as well as government. There are just a few exemptions. What are those exemptions? A Nepali citizen, except for Indian Foreign Service, Indian Administrative Service and Indian Police Service, he can apply for any other kind of service. So for example, he can apply for Indian Revenue Service, Postal Service, etc. Okay. So in this way, that friendship treaty is beneficial to Nepal, citizens of Nepal. Okay. Next, apart from that, Nepali nationals also work in Indian private sector and also public sector. So we all witness in our day-to-day life that Nepalis are involved in our private sector job and also in military. Okay. In military also, in army, we have Nepalis and they can raise up to the rank of what? 2-star generals. So the efforts have been made to bring some reforms in this treaty, but still no significant development has taken place. Okay, no significant development has taken place. Next, heat and state. So this is the article with respect to the deaths that have taken place in Uttar Pradesh and Bihar because of the heat waves. Okay, because of the heat waves. But here we understand that the actual reason for the deaths is not only the heat waves, but also because of the poor infrastructure. Okay, poor infrastructure may be like contaminated water and poor social security. So all these various factors have come together and contributed to the death, and it is not heat wave alone. So that is what has been highlighted in this article. Okay, that is what has been highlighted in this article. Okay, so in order for a proper health, so only heat wave for the deaths, only heat wave was not responsible, but the other factors are also responsible. So there are few terms which are highlighted. So what do we understand by medical certificates of the cause of death? We need to understand this term, and also we need to know who is Registrar General. Okay, who is Registrar General? Who is Registrar General? So other things, just ignore it. Okay, ignore it. This article is not that much important. Okay, it's not that much important. It does not consist of much useful information. Anyhow, I'll be sharing the link of the PDF. You can download the PDF and just go through the content. Okay, go through the content. Next, spare a thought to psychiatric caregivers too. Very important. Okay. So here in this article, there are a few things which are important from exam point of view. Exam point of view. So National Health Mission, it says that around 6 to 7% of India's population suffers from mental disorders, one or the other mental disorders. So this disorder, it worsened when during COVID-19 pandemic, because there were long periods of isolation, so fear of losing loved ones, financial difficulty, uncertainty about the future. So all these, they increased mental illness. So most of these cases remain untreated due to ignorance and social stigma. So many of them who are facing from the mental illness, they themselves don't know that they are facing a problem. And also at the same time, they do not want to consult a doctor and all, because socially they will be stigmatized. So these are the various reasons. But here in this article, the major focus is on the caregiver, because the person who is suffering, he needs a caregiver. So here the focus is on caregiver, especially women. Okay. So as a person is facing a mental problem, similarly, continuously a person who is involved in caretaking, they are also mentally disturbed, mentally stressed, equally stressed. Okay. And in the backdrop of reducing family size, now in India, so nuclear families are increasing, when only husband, wife and children will be there. So the burden will come on the spouse. So all these factors are what increasing pressure on the caregiver. Okay, caregiver. So here in this article, they have highlighted that equal attention should be given to the caretaker as well. Caretaker as well. So the National Mental Health Program and the Decentralized District Mental Health Program. So this is very important. So they remain focused on the patient but neglect caregiver. So this point is very important. So these programs, they are focusing on the patient but they have neglected the caretaker. So the point here that we need to emphasize here is that we also need to pay attention to the caregiver as well, or caretaker. Next, though private mental health institutions exist to take care, but the services are so expensive that everyone cannot afford the private mental health institutions. Private mental health institutions. Then a very important point from both Prelims as well as Mains point of view. So the Mental Health Care Act of 2017, it provided a corrective step with the mandate to treat mental disorders on par with physical disorders for insurance coverage. So whenever we are taking an insurance coverage, so generally physical things will be covered. For example, if there is an injury, if there is an accident, or if you want to replace if you want to undergo some kind of operation and all, those things will be covered. But mental disorders, generally private sector will not be interested to cover under the insurance coverage, fearing that it can be misused. But the Mental Health Care Act of 2017, it mandated that so mental disorders have to be treated on par with physical disorders when it comes to insurance coverage. That is why private sector, they cannot deny to cover mental disorders under the insurance coverage. So very important point to note, important from both Prelims as well as Mains point of view. Mains point of view. Next. Next, government schemes provided by like Ayushman Bharat. So again, very important point to note. Generally, UPSC may ask us a question to confuse us. So Ayushman Bharat, whether it covers only physical disorders or also mental disorders. So very important. Ayushman Bharat, it covers what? Mental disorders apart from physical disorders. Okay. It extends coverage to both mental disorders as well as physical disorders. However, what we need to understand here is private insurers, they are very much interested in physical disorders and they are not willing to extend to what? Mental disorders. Okay, fearing its misuse. So from Mains point of view, also need to understand that there are some non-governmental organizations like Mindroot, Lone Pack and White Swan Foundation. So they have been engaged in order to address the problem of mental disorders, but whatever the work they are doing, that is not sufficient in a vast country like India. Okay, so these things we have to take it in mind. Next, rethink the retention of sedition, a very important article, So first we need to understand what is sedition. So sedition is something you do against the nation's interest. So that will be considered as sedition. So where is this sedition defined? Section 124 of the Indian Penal Code, it deals with sedition. Okay, it deals with sedition. So Supreme Court of India in SG Ombatkere versus Union of India in 2022. So what Supreme Court did it in this judgment, it said that whatever the cases related to section 124A of IPC are there, so they should be kept in abeyance. Means you should not take action. You should not take action. For time being, you just don't take any action under section 124A of the IPC. This was the decision given by Supreme Court in this case. Okay, in this case. So Supreme Court felt that section 124A of the IPC, it does not suit the modern values. So this was the interpretation, this was given by Supreme Court judgment. But the Law Commission of India, recently in the Law Commission of India, in its report, it has said that we need to retain it. We need to retain it. So Supreme Court has said that we should not, as far as possible, we should not use section 124A, whereas Law Commission has suggested that we need to retain it. And in order to retain it, they have also defended it by saying that why it is necessary, it is useful to counter the threat to India's internal security. So in order to address the threats to India's internal security, we require section 124A. This is the suggestion given by Law Commission. Okay, Law Commission. And in this context, one more act has appeared, Unlawful Activities Prevention Act. Okay. So there are some suggestions that section 124A should be removed. And because already we have Unlawful Activities Prevention Act. When Unlawful Activities Prevention Act is there, why do we require section 124A of IPC? So these were the questions that were being posed. So here we need to understand that whatever the UAP, Unlawful Activities Prevention Act, it does not cover all the elements of offense envisaged under 124A of the IPC. Means all the offenses which are present in 124A, so all those are not covered in UAPA. That's why we cannot remove what 124A. So this is the stand. Also recommended certain procedural guidelines to prevent misuse of section 124A of IPC. So Law Commission, it said that we have to retain section 124A of the IPC, but it also said that as this section should not be misused for political reasons, it also gives certain procedural guidelines that have to be followed while booking a case under section 124A. Okay, 124A. So in order to retain, while suggesting, it gave the example of Maoists. Okay, it took the example of Maoists. So as the Maoists are increasing, or their threat is increasing, that is why section 120, retention of section 124A is necessary. This was the stand taken by what? Law Commission of India. But if you look at the Maoist violence, okay, Maoist violence, so it has almost come down, but the highest violence that has been reported in the last 5 years is in Chhattisgarh. So again, this point is important from Prelims point of view. So Maoist violence has been coming down in the recent years, but the highest Maoist related incidents we have seen in Chhattisgarh. And here we come across one more organization, National Crime Records Bureau. So whenever we come across such kind of organization, it should arouse curiosity in us. So what kind of body it is, whether National Crime Records Bureau is a constitutional body or a statutory body or non-statutory body. So we need to ask a question and we need to find it. So what kind of body it is. So NCRB data, it shows that so cases registered under section 124A of the IPC are almost close to zero, means 1, 2 or 3 cases. So it means section 124A of the IPC has not been used effectively to tackle Maoist violence. Similarly, cases registered under the Unlawful Activities Prevention Act are also almost close to zero. So it also means that UAPA has not been used to address the challenge of Maoists in the recent years. Then if section 124A and UAPA are not used, then what are the various acts that have been used by the Chhattisgarh government to address the problem of Maoists? So they have invoked many a times Explosive Substances Act and few provisions of the Indian Penal Code in order to tackle the threat of what? Maoists. Because Maoists generally, they use what kind of devices? They use improvised explosive devices. So what are improvised explosive devices? So improvised explosive devices are the one which are not made by experts, with whatever raw materials that are available, with the help of those raw materials, they will be building the what devices which can explode. So such devices we call it as improvised explosive devices. So in Chhattisgarh, rather than using UAPA and section 124A, generally the investigating agencies and the others, they invoke Explosive Substances Act and few of the provisions of the IPC in order to what? Charge people of Maoists. Okay, charge people of Maoists. Next, here a very important point to note. So unlawful activity. So where it is defined, this term is defined under a law, that is Unlawful Activities Prevention Act. So here what is considered as unlawful activity? Any action taken by an individual, it may be an individual or an association, which causes or is intended to cause disaffection against India. So whenever an individual or an organization is involved in some kind of activities which becomes a threat to India, then such an activity can be classified as unlawful activity under Unlawful Activities Prevention Act. So whenever a person is charged with unlawful activity, then what will be his sentence? He can be imprisoned up to maximum of up to 7 years, and there can be even a fine as well. Even these things are important. Okay, such kind of questions might be framed in prelims. Here in this context, we need to understand the difference, one important difference between section 124A and UAPA. So in section 124A, the term that is present is threat to government established by law. The term that is present is threat to government established by law in India. Whereas in Unlawful Activities Prevention Act, the term present is threat to India. Okay, threat to India. Threat to India. Next, Supreme Court in one of its judgment, it has said that criticizing government does not fall within the ambit of sedition. So why we say that section 124A of the IPC is being misused? Because generally whenever someone speaks critical of the government, so government will invoke article number 1, section 124A of the IPC and book them. So generally it is politically motivated. That's why Supreme Court in a judgment it has said that criticizing a government should not be what interpreted as what sedition. Okay, as sedition. Next, one more important is prosecution under the UAPA requires central government sanction. So directly in prelims they can frame a point. So when it comes to prosecution under Unlawful Activities Prevention Act, whether central government's permission is required or state government's permission is required, or we can take permission from any of these governments. No. Here, whenever we want to prosecute a person or an organization under UAPA, so we need to take the sanction of the central government. Okay, we need to take a sanction of the central government. So from the mains perspective, when we are writing our answers and we want to speak in favor of the abolition of Unlawful Activities Prevention Act, we can take the example of what not Unlawful Activities Prevention Act, section 124A. So United Kingdom has abolished the sedition, law on sedition, through an act in 2009. So generally we have borrowed the section 124A of IPC and all from UK. That original country itself has abolished, so it is now on our part to abolish section 124A. Okay, section 124A. Now I said that Law Commission, apart, it has suggested that section 124A of the IPC has to be retained, but it has also made certain what suggestions. So it has made few suggestions related to first information report and preliminary inquiry. So the Law Commission says that section 124A of the IPC has to be retained, but whenever you want to file a FIR against a person under section 124A, then before filing an FIR, first inquiry has to take place. So this is a suggestion given by Law Commission. But the existing practices, they deviate from the suggestion made by Law Commission. What are the existing practices? The existing practices says that, so when the offense is cognizable, there are two kinds of offenses: cognizable offense and non-cognizable offenses. So cognizable offense and non-cognizable offenses, these offenses are defined under Criminal Procedure Code. So whenever a person is involved in a cognizable offense, so no arrest warrant is required. So immediately you can file an FIR and you can arrest him. Okay, you can arrest him. But if it is a non-cognizable offense, then in order to arrest a person, an arrest warrant is required. So here, the established standard says that whenever there is a cognizable offense, an FIR has to be filed. Okay, and whenever there is a non-cognizable offense, so an FIR cannot be filed immediately. What preliminary inquiry has to take place. So now the Law Commission has suggested that preliminary inquiry has to take place, and then itself first information report has to be filed. So it is presently inconsistent with the present practices, so it may cause a problem. So that has been highlighted by the writer. Okay, so and also in order to make changes to it, we need to bring changes to Code of Criminal Procedure. So why we need to bring a change to Code of Criminal Procedure? Because Code of Criminal Procedure deals with cognizable and non-cognizable offenses. So what kind of offenses have to be considered as cognizable? What kind of offenses has to be considered as non-cognizable? So in order to make it adhere to the new suggestions of the Law Commission, so changes have to be brought to the Code of Criminal Procedure. So these are the various challenges which have been highlighted by the author. And also, if at all you bring a change to this Code of Criminal Procedure, then chances are that if someone challenges this code, the modifications in the Supreme Court or High Court, then it may invalidate such changes by pointing to Article 14 of the Constitution. So the Article 14 of the Constitution, which speaks about right to equality. Okay, right to equality. Okay, so this was about what? Abolition of section 124A. Next, in one more article, we have again about Unlawful Activities Prevention Act. So we shall understand its basics. So in Telangana, many cases are being filed against the Maoists and other people under Unlawful Activities Prevention Act. Okay, Unlawful Activities Prevention Act. So Chief Minister is against slapping of draconian UAPA law arbitrarily. So Chief Minister is a bit angry because police officers and all, they are booking the people under these Unlawful Activities Prevention Act. So that should not happen. It should not take arbitrarily. So Chief Minister has expressed it. So many in state are facing UAPA charges. So in Telangana state, many are booked under UAPA, and it is very difficult once you are booked under UAPA, because in normal cases you will get bail easily. But if you are booked under Unlawful Activities Prevention Act, then getting a bail is very difficult. So here we have to learn about few important points. So what are those important points? Here. So section 3 of the UAPA says that a sign gesture, word or intention can be construed as unlawful to implicate people without proof. Okay, some kind of sign, some kind of gesture or some word which have been spoken, it can be interpreted as unlawful and a person can be booked under Unlawful Activities Prevention Act. So this provision gives the police the power to book people arbitrarily. Okay, arbitrarily. So that has been focused here. Next, section 43 of the UAPA, that exact section 43 and all, they are not important. But some provisions of UAPA have been termed as very cruel and stringent. So what are those provisions? So a magistrate or judge hearing the case, if it is satisfied that proof of involvement in a case to deny bail. So what does it mean? If a judge is satisfied that sufficient proofs exist that to consider that a person is involved in unlawful activities, then he can be denied bail. Okay, he can be denied bail. It means without sufficient evidence also, if a judge is satisfied, then he can deny bail. So this is what most cruel and stringent provision which is present in UAPA. Okay, UAPA. So in prelims they may ask you a question like this. So if judge is satisfied, then he can deny a bail under UAPA. Yes, that is true. That is true. Next, another contentious issue that needs attention is judiciary seeking the opinion of the prosecution before granting bail. In other cases, generally judiciary will not seek the opinion of the prosecution, but while granting bail to a person who has been booked under Unlawful Activities Prevention Act, he has to judiciary, it will seek the opinion of the prosecution. So again, this is also considered as a stringent provision which is present in Unlawful Activities Prevention Act. Next, another very important provision is confession statements. So we all know that self-confession is not admissible in court. But in case of Unlawful Activities Prevention Act, whatever the confessions the accused make, so based on those confessions, new charges can be filed against the accused. So he will be put in problem eternally. So these are few of the provisions which are considered as unhealthy. Okay, unhealthy. So also unlawful activities, people who have been booked under UAPA cases, you cannot withdraw the cases easily. Suppose if you do not have sufficient evidence, you cannot withdraw it easily because and process has to be a due process has to be followed in order to withdraw it. So withdrawing the cases of UAPA is also not easy. And in this scenario, if National Investigation Agency, takes under its control the investigation of UAPA, so it has that power. If it takes, then it will complicate the things. The things will become further complicated. Next, the gender gap in clinical trials and disease funding. So this is in the context of USA. That is why this article does not consist of much important information from exam point of view. So here what we need to understand at the superficial level is disease which affect men more receive relatively higher funding than those which affect women. So there are diseases which affect both men as well as women, and there are certain diseases which affect only men, and there are certain diseases which affect only women. So when it comes to funding, so the funding is biased. Whenever a research is going on with respect to diseases related to men, funding is more, but when it comes to diseases related to exclusively women, then the funding is less. So these things can be quoted in mains, but they are not going to be beneficial from prelims point of view. So here we discussed and tried to understand the articles which are present in The Hindu. So once we have gone through this content, I will urge you to answer these questions. These are practice questions. So if you want to answer these questions in the test mode, then a link has been shared here. So you can click on the link and you can answer these questions in the test mode. And if at all you are getting confused, you can come back to the video and watch this video again, and then you can try to solve the questions which are available. So these are the questions. So if you want to answer here itself, then you can answer through the comment box. So you can indicate the question number. And indicate the corresponding answer as whether true or false. True or false. I'll also be sharing the PDF of this file. You can access the same. So in this class we discussed about the editorial articles. We analyzed the articles, we understood the articles, and we also solved these practice questions. Similarly, every day we'll be discussing about the editorial articles from the examination point of view, from both prelims as well as mains. For all such updates, subscribe to our channel and hit on the bell icon. Thank you.